I thank Professor Sands. I know it's not Professor Pelé to address the court. Vous avez la parole, monsieur.
Over to you, Professor Pelé.
I will.
Mr. President, distinguished members of the court, my colleagues summed up in the limited time which they had the principal internationally wrongful acts to be attributed to Israel. Those have been more lengthily and precisely described not only in the written comments of the State of Palestine, but also in those of the vast majority of the 56 other states and international organizations who have participated in the written proceedings. So it falls to me right now to succinctly recapitulate not these egregious violations themselves, but the legal consequences arising from them. These consequences are the very subject matter of those two questions posed by the General Assembly to the court, since both of them relate to the legal consequences of the prolonged occupations of the OPT. Were I to restrict myself merely to commenting on the list alone of the internationally wrongful acts of which Israel is responsible, were I to do that, I would exceed by far the time at my disposal. May I thus be allowed, distinguished members of the court, to refer you to the passages in our written comments and those of the majority of states and international organizations participating in the written proceedings who set out these consequences in particularly relevant and careful fashion. Those references will be listed thanks to the diligent efforts of the registry in the reports of this hearing, and can also be seen in the overview table, which you can find under tab AP1 of your judges folder. It's rather a long table, I have to say. I'm going to say a few words about that in a minute. In any event, this listing calls for a number of comments, both preliminary and general. Firstly, as emphasized by the participants in the written proceedings, who are all in agreement on this point, the legal consequences for Israel arising from the applicable rules are primarily those codified by Articles 29 through 37 of the 2001 ILC draft on state responsibility. These deal, of course, with the full reparation of harm caused by actions or omissions of Israel, but also with their cessation, inseparable from the duty to carry out those obligations breached and the obligation to offer guarantees of non-repetition. Another point on which there is a very broad consensus relates to the nature of those obligations breached. Now, generally speaking, the participants to the proceedings consider that these are serious violations by Israel of obligations arising from the peremptory norms of general international law, whose definition and consequences are partially codified in Articles 40 and 41 of the Articles of the ILC. This is the case principally for the prohibition of acquisition of territory by the threat or use of force, the obligation to comply with the right to self-determination, a number of rules arising from humanitarian law or the protection of human rights, and specifically the prohibition of racial discrimination and apartheid. Let me point out en passant that this enumeration overlaps strikingly with the non-exhaustive list of norms that the ILC had previously designated as having this status of peremptory norms, which were annexed to the draft findings on peremptory norms of general international law, Jus Cogens. My colleagues have shown this at length, and I will revisit this again solely to illustrate the particular consequences which flow from the very nature of peremptory norms. Let me clarify, however, that these peremptory principles you can see in the table on screen are set out in greater detail on the in the document that you can find under tab AP33 in your files. The reason why it's helpful to single out these obligations is on account of their specific consequences. First, and this is the starting point, given that they are peremptory norms, they are binding upon and independent of the consent of their recipients. Secondly, unlike what some states would wish you to believe, you can't interpret them as derogating either from the rules of jus cogens, nor from the Charter of the UN, which constitutes the supreme norm, creating both the Security Council and the Court, and which, of course, binds them both. Furthermore, in no circumstance can exclude the wrongfulness of any act of a state which does not comply with an obligation arising under peremptory norm of general international law. This principle is codified by Article 26 of the ILC Articles of 2001 and is recalled by the equally important draft conclusion 18 of ILC drafts on peremptory norms of general international law. And finally, Israel can't hide behind alleged circumstances precluding wrongfulness to justify the violation of its obligations, which are peremptory and intransgressible. Let me add that these considerations are equally valid mutatis mutandis regarding the obligations flowing from the resolutions of the Security Council, and first and foremost, of course, from those decisions taken under Chapter 7 of the Charter. And you can see the relevant list under Tab 3 of your folders. In no case may negotiations call into question the norms of jus cogens, one of whose main consequences, as you well know, is the voiding of any treaty if, at the time of its conclusion, it conflicts with the peremptory norm of general international law. So, the conclusion of negotiations may in no case be contrary to the peremptory norms which I set out just a few minutes ago, nor contrary to the binding resolutions of the Security Council, though these resolutions generally rehearse the former, applying them to the specific context of our case. Mr. President, contrary to what the US implied in their written comments, the holding of negotiations is not necessary for us to draw the consequences of Israel's violations of its international obligations. Once violations has been established and attributed, and in this case this is beyond dispute and indeed is undisputed, the responsibility of their author exists ipso facto with all attendant legal consequences. Now, to deny this, some states, a few states, have invoked inter alia one sentence quoted out of context, taken from your opinion of 9 July 2004 in the Wall case. I quote, "This tragic situation can be brought to an end only through implementation in good faith of all relevant Security Council resolutions, in particular resolutions 24-2/1967 and 33A/1973. End of quotation. But all you said there is that the state of Palestine, which is ready to do so, and Israel, which appears far from it, must apply the resolutions of the Security Council. And they must do this both during and independently of any negotiations. And in your opinion on the Wall, you never considered that the so-called negotiating framework prevented you from ruling on the legal consequences of its illegal construction. May I add that neither Resolution 242 nor Resolution 338 refer directly to the responsibility of Israel for its practices and policies towards the Palestinian people. Only the second one of those, the Resolution 338, calls for, I quote, calls for negotiations between the parties concerned under appropriate auspices aimed at establishing a just and durable peace in the Middle East. So it's not a question of responsibility, and this question is as topical as ever. Now, sticking to the wall opinion, you called the General Assembly's attention, and I quote you here, to the need for these efforts to be encouraged with a view to achieving as soon as possible, on the basis of international law, I repeat that, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region. Let me underscore, on the basis of international law, sur la base du droit international. Another consequence of the peremptory nature of the norms breached by Israel is that Israel cannot rely on any circumstance to escape its responsibility, be it on the grounds of some consent purportedly given by the State of Palestine, or by invoking self-defense or necessity. No more may Israel justify countermeasures as a response to an internationally wrongful act that it might impute to Palestine. As the ILC noted quite rightly in its commentary of Article 26 on its articles of state responsibility, I quote them there. For example, a state taking countermeasures may not derogate from such a norm. The plea of necessity cannot excuse the breach of a peremptory norm. End of citation. The State of Palestine does not deny that to practically implement Israel's obligation towards it and the Palestinian people, that negotiations could be useful, indeed necessary. But as far as peremptory norm obligations are concerned, this would only be to settle practical issues. There is no way that such negotiations, or the perspective of such negotiations, could serve as a pretext to exonerate Israel from its responsibility, or lessening their consequences, or delaying their implementation.
You can, yeah, thank you. Yes, thank you. I apologize. Madam.
Distinguished members of the court, as you will recall, not only the State of Palestine, but also a number of other participants, the obligations incumbent upon Israel to draw the consequences of its internationally wrongful acts are unconditional and immediate. That's the case for the obligation to put an end immediately and unconditionally to, and completely, to the occupation of Palestinian territory, including East Jerusalem. This is an occupation, as you well know, lasting almost 57 years. As I say, the obligation to put an end immediately, unconditionally, and completely to the occupation of Palestinian territory, including East Jerusalem, an occupation lasting almost 57 years, violating inter alia the prohibition of the acquisition of territory by the threat or use of force, the right of the Palestinian people to self-determination, the prohibition of racial discrimination and apartheid, and those fundamental principles protecting human rights and arising from humanitarian law. Now, it's also the case for the obligation to cancel all legislative or regulatory texts aimed at annexing East Jerusalem or any part of the territory of East Palestine in disregard of its territorial integrity, as well as those organising the exploitation of its natural resources. The obligation as well to put an end to the policy of apartheid and racial discrimination of which the Palestinian people as a whole is victim, both in the OPTs and in Israel. This is also the case of the obligation to rescind all measures aimed at modifying the demographic composition of occupied territory, including Jerusalem and the status of the holy places. And in the same spirit, the prohibition to establish diplomatic missions in Jerusalem. The same applies to the obligation to dismantle settlements in the OPT, or the obligation to ensure the return of Palestinians expelled from Israel and from OPT and their descendants, and to restitute properties confiscated, be they property, both real and personal property, to their Palestinian owners, and to pay them, the owners, inter alia, appropriate compensation, and further, the obligation to search for, prosecute, and punish the authors of war crimes, crimes against humanity, including apartheid or genocide, or other egregious violations of human rights. May I be allowed to refer you, members of the court, to the table you can find at tab 6.1 of your folders, which summarizes, on the basis of the replies both of the State of Palestine and a number of other participants in the proceedings, those legal consequences on which you are called to rule. Mr. President, the secondary obligations, if you will, that I've enumerated thus far are the consequence of Israel's practices and policies pursued in persistent and egregious violation of the obligations of peremptory norms of general international law, and in first place of its illegal occupation, its denial of Palestinian people's right to self-determination, which is the source of all these evils. Were Israel to effectively and swiftly acquit itself of these obligations, Israel would be partially re-establishing the situation which existed before the wrongful act was committed. Without that, of course, adequately repairing the immense harm caused to the people of Palestine since the 1948 Nakba. To the extent that this harm cannot be repaired by restitution, Israel must discharge two other obligations consistent with the principles codified in Articles 34, 36 and 37 of Articles 2001. Israel must compensate the victims of its acts and give satisfaction in reparation of the damage caused by its internationally wrongful acts in the form of recognition of its breaches, expressions of regret, formal excuses, or by any other suitable means. I won't say more about compensation except to recall that reparation must be entire, and that it is essential for those Palestinians who are direct victims of Israeli atrocities inter alia on account of the infringement of human rights and humanitarian law, and in particular, I quote, the applicability of the Geneva Convention relative to the protection of civilian persons in time of war of 12 August 1949 to all the Arab territories occupied by Israel in 1967. End of quotation. This is a Security Council resolution. I continue. But in the framework of the instant proceedings, distinguished members of the court, it falls to you to affirm the principle of compensation and not the quantum. However, you can be more precise regarding the satisfaction that the State of Palestine is entitled to expect from Israel, especially given that the Security Council and the General Assembly have already made specific and legally binding findings in this respect. The Security Council in 1967, I quote them, talks about the acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area. This appeal to Israel remained without effect, but ought to have, and indeed should more than ever, encourage those states who have not yet done so to follow the example of the 139 states who've already recognized the state of Palestine. In that self-same resolution, the Council calls for, I'm quoting them again, the guarantee of the territorial inviolability and political independence of every state in the area. Every state. That includes, of course, without doubt, the state of Palestine. Now, these decisions, and these are binding decisions, were rehearsed, reiterated on numerous occasions since the important resolution 2334 of the Security Council of 23 December 2016, which is particularly important. And because it's so important, you will find it under tab 6.4 in your folders. It has to be said that Israel paid no attention to this either. Now, Mr. President, if ever there was a situation in which these guarantees of non-repetition foreseen by Article 30 of the Articles of the ILC apply, it is this case. For almost 57 years, despite the repeated appeals of the General Assembly and the Security Council of the UN, and numerous other international organizations, be they NGOs or governmental, Israel has obstinately stuck to its policy of oppression and discrimination against the Palestinian people in breach of the most fundamental principles of international law, and by its practices has continually exacerbated the situation with the unconcealed objective of making impossible the realization of the Palestinian people's right to self-determination. Let me point out once again that the Security Council has for many years expressly called upon Israel to discharge all of these obligations, as you can see in the table under tab 6.2 of your folders, which summarizes all the relevant resolutions of the Security Council. And the General Assembly insisted time and again on, I quote them, the urgency of achieving without delay an end to the Israeli occupation that began in 1967, end of quotation. And of course, as well to bring to an end the other violations of Israel and its obligations whose urgent nature it emphasized by saying immediately. Mr. President, given that it is legally impossible for Palestine to renounce requiring Israel to comply with its peremptory obligations, the Kogan's nature and the seriousness of their violations by Israel have major consequences for third states. Now, they are set out a minima in Article 41 of the ILC articles. The Security Council and the General Assembly have repeatedly called upon all states, I quote, not to provide Israel with any assistance to be used specifically in connection with settlements in the occupied territories. More broadly, they have equally reasserted the obligation of the UN and all states not to recognize the situation resulting from the unlawful occupation of Palestinian territory, not to provide aid or assistance, to make the distinction between occupied Palestinian territory and Israeli territory, and to comply with and enforce international law. This implies that the responsibility of Israel should be implemented and that the resolutions of the Security Council should be applied by practical means. Excuse me. Mr. President, principles set out in Article 41 describe some of the essential and indispensable consequences of any serious violation of the obligation of the peremptory norms of international law. Such norms are rare, it is true, but Israel has seriously and systematically breached most of them and continues so to do. So Israel must assume the consequences, and it's up to the court to remind Israel of them and to specify the contents thereof in the light of the facts of the case. Once again, because I don't have the time and because iterari iadem omnia diabolicum, I humbly request you to refer to the relevant paragraphs of our observations, in other words, of our comments and written statements. I'll merely recall in telegraph style that third states, starting with the UN, must prohibit the provision of Israel with any military or technological assistance which could be used in the OPT, including Gaza, of course, to perpetuate or reinforce its occupation and the regime of racial discrimination and apartheid instituted by Israel. This prohibition covers all authorizations for any type of arms trade which could be used to such ends. Third states also have to aid and assist Palestinian people, including refugees from the time of Akbar up until those who have fled recent Israeli atrocities, giving them the means necessary for their subsistence inter alia via competent international organizations. And that will surely include UNRWA. Third states they must refrain from any form or economic relations or other relations with Israel involving the population or the natural resources of the OPTs without the express agreement of the legitimate representative of the Palestinian people. Third states also must ensure that their own nationals do not pillage nor unduly appropriate these said natural resources. Third states have the obligation to cooperate with a view to effectively realizing the right of the Palestinian people to self-determination. They must also prosecute and punish all individuals responsible for serious crimes under international law, including their own nationals, before national courts or by cooperating with the ICC. Now, there is a point on which I'd like to more especially draw your attention, distinguished members of the court. This relates to paragraph 3 of Article 41, which specifies that it is without prejudice to further consequences that without prejudice to further consequences that a serious breach as defined by Article 40 may entail under international law. End of quote. As from then, the obligation of third states and the UN don't stop at these duties of cooperation and non-recognition. As Palestine explained in its written comments, they have an obligation, both customary and conventional, to pursue, punish or extradite the authors of violations, be they war crimes, crimes against humanity, the crime of apartheid, not to mention acts of genocide committed against the Palestinian people, whose plausibility you recognized in your order of 26 January. Moreover, you expressly recalled in your opinion on the wall, I quote you here, all states parties to the Geneva Convention relative to the protection of civilian persons in the time of war are under an obligation, while respecting the UN Charter and international law, to ensure compliance by Israel with international humanitarian law as embodied in that convention. This obligation covers